what we witnessed yesterday, the well choreographed, well planned, well orchestrated acquittal and discharge of Madam Sedinam Tamaklu, who stole some 90 million Ghana cedis by the Court of Appeal. What we witnessed yesterday is not an isolated judicial outcome, no. It was the unmasking of a system, and this afternoon, we intend to expose this system and confront it squarely. Yesterday, Thursday, 30th July, the Court of Appeal acquitted and discharged Madam Sedinam Christine Tamaklu Ationu, former Chief Executive Officer of Maslock, stripped away the judicial ropes and the licensed phrases, and what remained is this: a woman convicted on the multiplicity of accounts of stealing, causing financial loss to the state, money laundering, breaches of our Public Procurement Act. And this lady was sentenced to 10 years imprisonment for plundering almost 19 million Ghana cedis belonging to the poorest Ghanaians, the market women, the farmers, the poor traders. These monies are meant for them. And yesterday, she was given her liberty. Barely 7 weeks after the taxpayer funded her extradition from United States of America. Consider this record, because the record is damning. This was a 5-year trial before a court of competent jurisdiction. 5 good years. The prosecution's case was built on documentary evidence, forensic audit, and sworn testimony. The convicting judgment of her ladyship, Justice Afia Sewa Asariboche, which we challenge every journalist, all of you here, we challenge you to go and read the judgment. It is very meticulous, count by count dissection of fraud, fictitious disbursement, monies meant for struggling market women dissipated. You remember the Kantamanto market? This woman dissipated monies meant for them. And above all, serious breaches of our public procurement laws. No serious lawyer or no serious Ghanaian who has read the judgment can honestly describe the evidence as seen, describe the evidence as anything other than overwhelming. She did not stay to answer it. She fled the jurisdiction mid-trial and was convicted in absentia. A fugitive from the very justice system that has now embraced her and freed her. And yet, within 7 weeks of her forced return, the conviction has evaporated. We ask the questions every Ghanaian is asking. On what principle of law does a mountain of evidence become a mirage? Which findings of fact were perverse? Which directions on the law were wrong? The Ghanaian people are entitled to answers because justice under our constitution is administered in the name and they can smell what this is. This was not an appeal succeeding on its merit. This was an overcome, procured, packaged, and well delivered. The NPP states without fear of contradiction, this acquittal was politically motivated, well orchestrated and planned, and its timing on the eve of legal vacation, with public attention divided, is no coincidence, and it's not an accident at all. And we hear the Attorney General says he's going to go before the Supreme Court on appeal. It is all part of the well-choreographed plan. Commencement of trial was 30th January 2019. Charge sheet was filed at the High Court Criminal Division. In all, 78 counts were filed. In all, 78 counts were filed. Among these offenses were stealing, conspiracy to commit crime, willfully causing financial loss to the state, conspiracy, improper payment of public funds, unauthorized commitment resulting in financial obligations for government, breaches of our procurement law, on 24th, and this will blow your mind, Madam Sedinam Tamaklo advanced a loan to Obatampa Savings and Loans. It was a check, ADB check. The moment Obatampa Savings and Loans received this check, they asked of the interest. And this is even poor administration of Maslock. Why would Obatampa ask of an interest after the monies have already been advanced to them? And the interest was mentioned to be 4%. And they said, no, we cannot. Because we deal with farmers here, we deal with market women here, they cannot pay the 4%. And Madam Sedinam Tamaklu told the man to return the money. The man should cash the 500,000, cash, and bring it to Accra. The man obliged, cashed 500,000 Ghana cedis, met Madam Sedinam Tamaklu at Bachuna Tota, packed the money in her car boot, and she departed. And she gave her a written consent that she has received the money. The monies were not lodged into Maslock accounts. Forensic audits revealed that the monies were never deposited in Maslock accounts. Yet we are being told that she did nothing wrong. Again, the board approved 1.6 million for her for sensitization and training program. She withdrew more than what the board approved. 1.816 million was withdrawn. Out of it, do you know how much she disbursed out of the 1.8 million? 1,300 Ghana cedis. The rest in her pocket. 1,300 Ghana cedis. Without compliance with the Public Procurement Act, she again signed a contract purchasing 350 vehicles. And it will surprise you. Let me go through it. I'll come back to the Kantamanto fire. Now, in 2016, without PPA's approval, she signed a contract for the supply of 350 vehicles, comprising 150 Avio Saloon, 100 Chevy Sparklights, and 133-seater Isuzu buses. On the Avio Saloon, she purchased one vehicle for $18,883, though the market price was $12,000. The market price was $12,000. Yet she alone bought it for $18,000. On the Chevy Sparklight, she bought one for $16,500. Again, the market price was $9,100. On the Isuzu 33 Basita, she bought one for $112,000, $942. But the actual price was $74,493. In all, she pocketed $4.1 million, almost 50 million Ghana cedis. And the evidence is clear. These matters were investigated thoroughly. And yet we are being told that she should go home free with our money. In fact, at a point when a certain Samsung phone was on the market, selling on the market for 100 Ghana cedis, normal young phones, she alone bought it for 400 Ghana cedis. 400 Ghana cedis. You recall the Kantamanto fire, where 1.4 million Ghana cedis was meant for our market women. This woman pocketed 600,000 Ghana cedis. 600,000 Ghana cedis. At a point, she requested that she needed to seek medical attention. She never returned. 2021, 22, 23, 24, 25, and she returned 26. And in less than 2 months, she's been freed. Ladies and gentlemen, again, unapproved payment of 273,000. These monies again went to her. She paid herself and her deputy 135,000 Ghana cedis, 82,000 Ghana cedis, 28,000 Ghana cedis as ex gratia, unapproved. And she was meant to go through the judicial process fairly. She was never under any duress. And at the time, following her refusal to join the trial, on an application by the prosecution, the court on 24th, she left on 24th January 2023, ordered that her trial be held in absentia. She left in 2021. And the prosecution relaxed on their constitutional rule just because of fair trial. So 2021, she left. 22, she was not in the country. 23, that was when the prosecution put before the court an application for her to be tried in absentia. And again, to ensure that she was duly notified, the court further ordered that she be served by substitution in the following manner through her lawyers, Agbesi Jakwasu Esquire. Her last known place of abode, publication in the national dailies and on the notice board of High Court for 21 days. After 21 days, she still failed to show up. Then trial proceeded in her absence accordingly. On 16th April 2024, judgment was delivered and she was sentenced to 10 years imprisonment. The trial judge in the judgment evaluated the evidence on record, including the cross-examination done by Sedinam Tamaklu's lawyers, her charge, and her caution statement. After the judgment, extradition request commenced under the 1931 extradition treaty with U.S. By July 2024, all the documentation from the AG's office had been completed and submitted to the U.S. authorities. In August, U.S. informed the AG's office that they had located her in the U.S. Her residential address was known and all her movement under surveillance. They placed her on the stop list. The U.S. kept updating the AG until January 2025 when government changed. There was absolutely nothing left for government of Ghana to do. Every further step was left in the hands of the U.S. government. Ladies and gentlemen, let me proceed by stating that it has become the modus operandi of this Attorney General. It was an agenda well conceived to free all their people. And I'm going to give you an account on that. Check this. The snitch scandal. Is it not worrying that the High Court in Accra also acquitted and discharged the former Director General and Board Chairman and two others who were accused of causing financial loss to the state to the tune of 70 million? Again, by just a stroke of pen. The Attorney General entered nolle prosequi. And these are accused persons who were told to open their case. The court had ruled that you have a case to answer, so open your defense. Yet, the Attorney General, the current Attorney General, just went to court, entered nolle prosequi, and acquitted and discharged all of them. The Unibank scandal. Again, we are talking about a whooping 5.7 billion Ghana cedis. It included the founder, Dr. Kwabena Duffuor, and many others. In fact, including even the current governor, Bank of Ghana. And again, the court had ruled that they have a case to answer. Yet, this Attorney General, because it is already a well-conceived agenda to free their people, again went to court with a stroke of a pen, entered nolle prosequi, and freed all of them. We are talking about 5.7 billion Ghana cedis here. The Segleme scandal. Honorable Collins Downer and others. The monies involved, they were supposed to build affordable houses. And the monies were squandered. And they were standing trial for $200 million, the monies involved. And yet, the court had ruled that they have a case to answer. They must open their defense. Just when Attorney General, that was possibly the first set of assignment he was given. He again went to court, entered nolle prosequi, and the court acquitted and discharged them. Huge monies. Then the Cocoa Board scandal. Again, we are talking about 271 million Ghana cedis involved in this. And the Attorney General freed them. Attorney General freed them. These are all monies These are all financial loss to the state. So we are not surprised that from day one, they had already conceived that we are going to free Madam Sedinam Tamaklu. And it is worrying how the Court of Appeal would say. And I have this here, I'll read it out to you. In one of the rationale behind the judgment, Court of Appeal is saying the charge sheet was defective. How can the charge sheet be defective? How? When they never raised this matter during trial, it never came up. Even so, Section 406(1) of Act 30 is quite clear. And I'll read it to you. Subject to the provisions therein after contained, no findings, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered on appeal or review on account of any error, omission, irregularity in the complaint, summons, warrant, charge, proclamation, order, judgment, or other proceedings before or during the trial. And this is quite clear. So you cannot base, even though it is true, assuming without admitting, yes, that there were some errors on the charge sheet, which was never raised during trial. The judges at the High Court, at the Court of Appeal, did a great disservice to Ghanaians. Great disservice. We are talking about 90 million Ghana cedis. And we can just hinge her freedom on the fact that there were some technical errors, even assuming without admitting. So if there were some problems with the charge sheet, it means the person should run away with 90 million, when indeed Section 406 is saying that, look, even if you have some errors or irregularities on the charge sheet, that cannot free. You cannot reverse a court of competent jurisdiction, the decision, based on errors or defects. Ladies and gentlemen, it is a wholesale amnesty for the politically connected, dressed up in prosecutorial discretion. But discretion under our law is not a private weapon. Under Article 296, it commands that it must be exercised fairly, candidly, and without, or it must not be done capriciously. What fairness, what candor is there in a prosecutorial policy whose only consistent principle is that the party card of an accused, Madam Tamaklu Ationu, stood convicted, so the front door of a noli prosequi was shut. Yesterday, the back door was open for her. The Attorney General did not protect the public purse. He presided over a ceremony of betrayal. And I'm surprised. The Attorney General put in a very weak and a relaxed defense before the Court of Appeal. I think that the judges at the Court of Appeal should have done better. They should not have relied on some of these things, especially when 90 million Ghana cedis is at stake. Because the Attorney General is part of the choreography. So they put in a very weak defense, very relaxed defense. In fact, it was even captured in the statement. Let me also read this one to you. It was captured in the written submission of the respondent in answer to the appellant's submission pursuant to leave granted by this honorable court. And I'll read just a small portion. We wish to bring to the attention of the honorable court that the record of appeal before the court is not complete. We state that all the exhibits tendered by the prosecution during trial does not form part of the record. The only document found as part of the record are some of the documents which formed part of the disclosure done by the prosecution. So it was even revealed that the Attorney General put in a very weak, very relaxed, very ill defense. So obviously, as we have predicted all this while, the entire choreography was to release and free Madam Sedinam Tamaklu. And to our judiciary, we say this with heavy hearts, but steady voices. Every judge of the Superior Court swears to do justice. And Article 17 of the Constitution guarantees every person's equality before the law. Yet, the pattern now staring the nation in the face is the two-track system of justice. One track, swift, forgiving, and generous for friends of the government. Another, harsh, hurried, and merciless for the opponent. Selective justice. And I keep saying this. There is a certain fear hovering on the judiciary. From 1992, we have never, no government, no president, we have never ousted our Chief Justice before. Never. It is only under President Mahama, who promised NDC members that he was going to sanitize the judiciary. And indeed, it was part of their plan to oust the former Chief Justice, Madam Tokono. So the message is clear that if the president has been able to put in a system to remove the Chief Justice, then who am I? So it looks like, it appears, and that is what I see, because I have been in court where a whole judge, a circuit court judge, is celebrating Idi Amin, such a notorious tyrant, such a notorious dictator. The judge is celebrating Idi Amin in his ruling. In fact, in his ruling, he stated that although all of us are equal before the law, as stipulated by the Constitution, in practice, some are actually above the law. That is what he said in his ruling. And do you know where this judge is now? He has been promoted. He's at the High Court now. He was the same judge who again introduced Animal Farm in his judgment. Such poor judgment, which received several criticisms. That ruling was widely condemned. Yet, he has been promoted to the High Court. So now the impression is that the impression is, do the bidding of the sitting government and you receive promotion. So there is a certain fear hovering over the judiciary. And that is why we say democracy under siege, democracy under attack. A judiciary that convicts the opposition on thin evidence in record time, whilst government allies walk free against overwhelming evidence, is not administering justice. It is administering politics in judicial costume. Public confidence in the court is the only currency the judiciary possesses. And yesterday, the currency was devalued before the eyes of more than 33 million Ghanaians and the international community. The message this government sent to the world yesterday is chilling. In Ghana today, accountability is for the opponent, and impunity is for friends. Steal for the party in power, and the law will find you innocent. Oppose the party in power, and the law will find you guilty. Ladies and gentlemen, yesterday's acquittal cannot be viewed in isolation. It is the latest chapter in a sustained assault on the pillars of our Fourth Republic. Overnight, the Mahama-led NDC government has succeeded in undermining almost every single index of good constitutional governance in Ghana. This is their record. The removal of former Chief Justice. Let it never be forgotten where this all began. The murky, opaque, the constitutionally suspect process by which Her Ladyship Chief Justice Gertrude Araba Esaba Saki Tokuno was suspended and ultimately removed from office. That removal, conducted behind closed doors and in defiance to every principle of due process, transparency, and natural justice, was not an isolated act. It was opening move, the very beginning of a deliberate agenda to decapite the judiciary, capture it, and destroy the last institutional safeguard of good governance in this country. Everything we have witnessed since flows from this originating sin. And I keep saying, eyes are watching the Chief Justice. My Lord Bafuboni, eyes are watching you, because you are the greatest beneficiary of this suspension and removal of Chief Justice Tokuno. Eyes are watching you. Again, your wife is also another great beneficiary of President Mohammed's administration. She was appointed to be Director General Prisons under President Mahama. So eyes are watching you. If things are not going well, if justice is being skewed, the legitimate questions people will be asking in their minds will be, is it because, my Lord, you have benefited greatly? Eyes are watching. Questions are being asked. And these are legitimate issues. You are now the Chief Justice appointed by President Mahama after the suspension and removal of Chief Justice Tokuno. And again, Madame Bafuboni has also gotten an appointment as the overall boss, Ghana Prisons. So is it the case that you cannot speak true to power? Is it the case? These are questions people are asking. Is it the case that there is that fear hovering over the judiciary? Is it the case? Are your people administering justice in fear? These are troubling times for our democracy. Troubling times for our democracy. Interference with the judiciary. The independence of our courts, the last refuge of the citizen, has been systematically compromised, with judicial outcomes increasingly tracking the political interest of the governing party. A brazen display of selective justice. Persons affiliated to the NDC are freed, discharged and acquitted, while opponents of government are hounded, convicted, and jailed on the flimsiest of evidence. The concentration of all so-called Operation Recover or Loot cases before only 2 judges, Justice Achibonga and Justice Kokuvite, who between them handle every one of these politically charged prosecutions, and whose conduct on these trials has strongly undermined the effort of accused persons to defend themselves. Now, these 2 judges, they are supposed to handle all cases involving NPP elements. All cases. And indeed, they have also been sanctioned. They have been given strict instructions not to go on vacation, because the courts are on legal vacation, but they have been told, hey, stay back and make sure you do all these cases. People asking questions, why only these 2 judges? Why? Why only these 2 judges? The baseless punishment of political opponents while NDC members walk free. A 2-tier system of justice in which the scales are weighed by party colors rather than evidence. We have witnessed over the years, a year and more or so, where operatives of NPP are picked up the moment they make the slightest of comment, which is deemed to be offensive to President Mahama and the government. A lot of people have been arrested, and they have been refused bail. So many, in fact, my last count reviewed 25. In fact, and even yesterday, I have this here. They have arrested one Godfred Ansu Damwa for a post he made on X, asking questions on the widely circulated video between President Mahama and the National Security Coordinator regarding some 150 million. Since his arrest yesterday, and as I speak to you now, we don't know where he is. Sorry, we don't know where he is. Just yesterday, he was picked up. Godfred Ansu Damwa. He was picked up simply because he asked questions. And all of you have seen this video which went viral. He's asking that, and he's been arrested. Can you imagine? This is dangerous for our democracy, and it shows how the Mahama-led and his law enforcement agencies are weaponizing the power given them by Ghanaian people to prevent citizens from exercising their fundamental human right of free speech. Just yesterday, the hurried reintroduction of the widely decried public tribunal system, an institution Ghanaians rejected decades ago, now being resurrected as an instrument to harass opposition. All of us must fight this tribunal. Media, we must fight it. We must fight it. It is evil. The NDC intends to perpetuate evil with this tribunal. They intend to harass all manner of persons with this tribunal. We all know the tradition. We all know what this tribunal brings to mind. You all know. The courts are doing their work. The courts are doing their work. We must all fight against this tribunal. The NDC intends to perpetuate evil with this tribunal. The suppression and criminalization of free speech, with critics of the government facing arrest, prosecution, and intimidation for exercising constitutionally guaranteed rights. The imposition of repressive and onerous bail conditions by law enforcement bodies, designed not to secure attendance at trial, but to punish and harass the political opponent before any court has pronounced on their guilt. The law is that every accused person is presumed to be innocent. But what the NDC, what they are doing with bails, the way and manner, bails are meant to make sure that the accused person is brought before either the court or to aid with investigation. That is it. Nothing more, nothing less. Bails are not meant to be punitive. But under President Mahama, and recently even Honorable Haruna Idrisu even spoke against it, bail conditions are being weaponized as instruments of punishment. You go to Yoko, and this is the first time I'm hearing somebody can be giving a bail sum close to about 900 million, 800 million, 100 million, 150 million, 80 million, 50 million. Why? Why? Is this what we voted for? And indeed, if President Mahama thinks that because he was overwhelmingly endorsed, because of that, Ghana was sold to him. Ghana is his private property. So you think that if President Mahama had promised Ghanaians in his campaign message that when I come, I'm going to free Honorable Collins Dauda, I'm going to free Governor Esiama, I'm going to free Dr. Dufour, then he should have incorporated this in his campaign message. Because in the first 100 days, you freed all elements. In the first 100 days. Again, a veiled third-term agenda orchestrated by President Mahama himself. He is the one behind it. You ask President Mahama, oh, I am not interested. Oh, it's only the Supreme Court. There are some applications before the Supreme Court. Whatever day the Supreme Court decides, it is not my issue. As for me, I'm only committed to my third term. We must fight against it. And again, to our judiciary, any attempt to introduce any weird interpretation regarding Article 66 would throw Ghana into a political turmoil. 2 terms, 2 terms. It is dangerous. And people are fighting for it, in fact, including NDC elements. And trust me, I can tell you on authority that His Excellency, the President, knows about this. He is behind it. And all of these applications before the Supreme Court, they are politically sponsored. They are politically sponsored. And that is where the fear is. Because now if you have a certain fear hovering around our justice delivery system, and this application is before them, all of us, we must speak against it. Ladies and gentlemen, permit me to draw your attention to one development so bizarre it removes any lingering doubt about what is afoot. The Chief Justice of the Republic has issued a warrant authorizing these 2 very justices, Justice Achibonga and Justice Kwaku Vitei, to sit during legal vacation, which commences tomorrow, 1st August. Think of it. All judges of the Superior Court. It is precisely the 2 judges before whom every politically charged prosecution of opposition figures are before. Who must, and they must not pause, they must work through. Why this indecent haste? What is the emergency? the only reasonable conclusion available to any objective observer is that this is part of the grand scheme involving the Chief Justice, the Jubilee House, and the two justices to rush justice and to convict political opponent at all costs. Justice hurried is justice buried. Trials conducted at a breakneck speed through vacations with accused persons denied a fair opportunity to prepare and present their defense are not trials at all. They are choreographed conveyor belt to a predetermined conviction. Why do we do this? Without a doubt, our democracy is under siege. The 1992 Constitution, for which so many sacrificed, is being hollowed out before our very eyes. And all well-meaning Ghanaians, irrespective of political affiliation, ethnicity, or creed, must rise to defend this. Our demands. The New Patriotic Party demand the following. Since it is now abundantly clear that the Attorney General and the machinery of justice under the administration have no intention whatsoever of protecting the public purse, the Attorney General should, as a matter of consistency and fairness, immediately discontinue and discharge all appointees of the previous NPP administration currently standing trial. It cannot be the case that the law is a weapon against one side on the political divide and a shield for the other. The Attorney General must render a full public account of every case involving persons affiliated to the governing party that has been discontinued, withdrawn, or otherwise terminated since January 2025, together with the reasons thereof. The Judicial Council and the leadership of the judiciary must take urgent steps to restore public confidence in the administration of justice, which yesterday's decision has gravely undermined. Chairman Wontumi, the Ashanti Regional Chairman of the NPP, must be immediately acquitted and discharged and released. His conviction and the outrageous sentence of 20 years imprisonment with hard labor handed down barely 10 days ago were politically motivated and procured without sufficient evidence. A fact his lawyers have set out more than 20 grounds of appeal now pending before the Court of Appeal. A call to action. Massive protest ahead. Fellow Ghanaians, the time for silence is over. The New Patriotic Party hereby serves notice that on 6th of August, next week Thursday, 2026, in collaboration with other political parties, civil society, organizations, professional bodies, student movement, youth movement, and all well-meaning citizens, we shall embark on massive demonstration to defend our democracy. We are starting here in Accra and we'll be going to other regions as well to defend our democracy, our constitution, and the rule of law. I thank you, ladies and gentlemen of the media, for your attention. God bless our homeland Ghana. Make our nation strong. And penny-for, adofo, media for, and central for Moshia. Madaroma, ene jumedie, eye, jumedia, ehunhia yepa. Na, Samosha, and Yama Bia air coswo, our yatentin nimuno, ehu. Ye papa Chief Justice, Wadauro Masore. Nano enreye, Madam Sedinam Tamaklu, or no. Yabon kwedu, so what every Ghana sika, no dia wasani srim. What fa Ghana Japadian were Johnny free from her. A brand party bar bear pe, the Timiako Fanaba. Now what you mean, Nunia Chirika court is uncle free. Obia. Of far Ghana sika 19 million Ghana cedis. Otimimo bibusia. No bia busane se. Na insi hu said that's what. Was insi hu yo hamunchi chemunai. Ohamun chichemu nine, we de yentimintua, and if a sikana breme, sikana young fan commerce local council, near the Sini car boot, no call. Yajisika 1.8 million Ghana cedis. Yet the Quakoyan Chachre, a 1,003 Ghana cedis per, and a mammy or Yusuye. Yakwako toka, car nina bois, ebedu $10 million. Mammy kwa peje moi, was a car ne bois. $14.5 million. Or no quantity bear $4.5 million. At the account, over 50 million Ghana cedis. When you na a dance your when you na a dance your ginem, Nenso Yampemwa Yampemwa Ama ene court of appeal. Aye Ghana bonnet say a nay anunti no onko. Na when na kakwanya NDC aban abai omo faswa omo pese omo yi omo nkofo na omo gina 10 ye mu no omo nkofie obeka ya agreement scandal yeru Collins Dauda ene ni mpanifo aka na $200 million na na wo sa asem no mu yese na omo nkofie attorney general afa ne pen ne paper na de court ya makwan munya obi ankofie senate mpanifo ane wo hono mu a omo di Ghana dwirim over 70 million Ghana cedis ene eso omo nkofie senate cocoa board scandal ebaye over 271 million Ghana cedis na na ebon attorney general baya o si omo nkofie o the pen paper dia court o yi omo nkofie Unibank issues ebem we hu sikasema na ebon mu nyaa almost 5.7 billion Ghana cedis benefo ahodo a na ewom including Governor Bank of Ghana omo nyaa ne ese no omo nkofie onko ya depend paper dia court we a case ye interested be mumko sana said nam tamakuru de oyeye attorney general court wango cancel papa bia ho asema o kan na munyedu o de atentin huro ne court na court gina so na court ade edi court ho yawo ne say court bo ye sika ho ban it is attorney general kwa na omba no anka na asem ya court de asodie so da so say o sen ka bo ye sika ho ban na ni se wugina so say na charge sheet be defective emra no so kire say charge sheet cry defective and asem from so bi wo so kra na yenye ne sa yenka ne sa enye se do an say wo so di ko da bi ye hwehwemu enei ehu bi aba beto eye Ghana ya 10 years so ye judiciary ehu bi aba beto so adentia ekwan ya ye fa so ye yi eye chief justice tokunu free ho no emu ohwerem na ehu tene ehu bi aba beto mo so eti asem bia ebekọ bia na efa NDC ni bi ho no ye di no sonko asem bia ebekọ ayefa no NPP ni ho no ye di ni sonko e wo sa 10 ye de ye hwemna no so ne di adwuma nwanwa jaja onu ko ball eye Idi Amin ewo na asem kam se Idi Amin de wo se fa ahodie de a wo de kasa no betimi de ma na fa ahodie a wo benya wo kasa de chi no ade de ontimi fa ma na jaji odi we se hu enkomo ewo ne nkasa yemu ene jaji ama yabona baso ye ne ko high court teneni aba no Wontumi asemi wutimi se otan bi ewo akire nipa bi no mu piepia ne ma no. Yes, you may not like Wontumi, but I'm running Yamra. It will be a said one number of council on any concession. Now, Obia on Yakako fan say, oh, now, Ube 2 go be also. Say any pano, your fan say, oh, Ube dia dance krumu, now the tia Wontumi, wono, Ebemwako, Wanka Onye. No tia teacher inside the Wontumi. Now, Obia, what time you got your 90 million, yes, won't go. Ni ono na nya ne krata wonam kwan personal court kra ka no so nya ne krata no yesi ngono nko da fiase 20 years na ne wafa ye 90 million no a o dwane free chrome ha a fe nu abasansa na aban na aba no yesi ono nko ene Ghana ha o kasa na sa nya aban da ne aba bechewo o kasa na aban ni nyi ho ne aba bechewo na ye ka obi a wa benefit from free speech. What kind of casa boy dana kuma suo? Dear President Mahama. And Sembe na President Mama Krawan can for one in your penny, Nana Danko Kufado. Or Sana Danko Kufado call your cron for the bush and 4 years Cabano. We know, okay. And Sembe na million more NDC Pomanka. And Sembe no man can for judiciary. And Sembe Panomanka, Edidia Temfite. And Comodia Bonnie. If there is any party are benefiting from free speech, expressing view, so we'll cast someone who come as well. It is the NDC and President Mahama. So why? Then now by ne, yes, ya brand tebi Godfred Ansu Damwa. Ya kwa chino. Ada ya video I buy na President Mahama na National Security Coordinator na monoma. Yet say President Mahama num now can be 150 million bi. Brand say then na for 150 million if you fan eba no. Ya kwa chino. Because of that, ya kwa chino. The President Mahama say kan wo ba mu. And I catch a Ghana for say me ba ma be chicken go for say 2% get better one. President Mahama, Oba Bemuno. And then can share boss wo nam for form ye NDC for a omugina court anwa atentine ye di o masam me ba me ma attorney general ayo mo apepa o mo ho awomakwa nti ka fi se Ghana for beto aba ma ade no anye no campaign promise because I come here ko say e ya de hu hia wo ye pa because anya ba ko nya mienu nya miensa e keka ko be nsia na say eye wa won ko for no wabo po bi se wo ba no wa be yom ade na one country Ghana for say it's part of your campaign promise say wo ba won ko for a omugina attention ye ni mu no wo be ja wo mo mako ade baby adu no me say nya yen so yen kasa na ne ya me ya ne say to me a ye de ma President Mahama no overwhelming massive endorsement and the parliament obi anya endorsement massive say bi da. And none edidia ko NDC. Any President Mahama His Excellency Mutrim a you almost said Ghana to say ya toma mamo. Sansa yombe biano bien kasa. Dien chin chin. Yem. Na kesi there na branch on near NDC near NDC communicator. Etimi call live TV so. Let's see a friend list to one anajima. Eko kase former IGP. Okum nipa police headquarters video no ho munya mo hu bio se former IGP kum nipa bonko for firing squad kum nipa police headquarters ya nche no okaya kan se papa ya o hwe small arms so ono na distribute arms e de maboko amom kokon tokwa ebesi ne oda so na mo obi amfa ne sanka no abranti a oni hutiri hu pesa okohunahuna ayarefo ewo rage in fact a prime minister no kwa set up committee so onko so cross onko apan so onko obi okuta video na wakohunahuna ayarefo say such a criminal offense onam hon mo bi no ye ne bibia tigane ne selective justice ne komana ene ye komana abusan fo mesem bibia adu no Yen Kayanuntum, the New Patriotic Party, Nyami Aduma next week Thursday, on the 6th, ye see Montinso, ye tin Tesikokwa Chaben, say our democracy is under attack, our democracy is under siege. We are in dangerous times. Adintia. Say a nay. Saban kan sa yes ni say anye abaye obi bia ene Chairman Wontumi yeso okwa appeal me ni nsem a yeri ayi maame kwaku vite e de convict no dwu ho ntiase yen trase enkan kasa bon hyeyem nyame ya domo a on the 6th of August next week Thursday ye beti ye ho gu monten so na nye no kwa there will be series of actions ye nye din ade a esie ya nhwe ya Ghana democracy no ebesi ni trase we are in dangerous times we are in dark times and we must be careful debia medical ka say papa bafuboni wada roma ebra ye two justice chief justice tokuno eyawo na bae eti obi eka se you are the greatest beneficiary nipa ne dika sanse wonye mu mfaso ebra ye tu obi no wonye mu mfaso ye suspend na na acting chief justice ebra yi ni free ono asa ba chief justice ena ye maame bafo ni nso no ye wura mahama nso appointing no na na director general ema prisons eti papa se nyima bi wo no anhwe ne obi be free se sanse wonya mfaso die bi afri president mahama hunti no enema bi wo no mu a wontimi anhwe nka sanu bi beka no and the person may be right se papa se bia mfaso due bi a wonya free president mahama hunti so wanhwe ya enema ne bi wo no mu a wontimi nhwe ne mu nka ntense da bi yenya ne sa ene court a call legal vacation nanso ya chechiri judges from mienu nsa se chinchina legal vacation no omo nkoso ano mo ntena eye NPP nsem so why the indecent haste ye prepare ho sa de akwa he madam said nam tamakulu ye de na famre mu even when odwane ye kwa Africa Ghana ko bi ahwe no 5 good years ansa na ye di na asem Chairman Wontumi asem na 1 year ye piepia asem ne sa adai Mr. Media for Nyamiya Aduma next week Thursday on the 6th. Your 2 year hogu montenso, your tinte suko kracha abe. Your kracha abe say our democracy is under attack. On trinyama yi, send a name si kon yes sir, and ye di Ghana, ejano. Busha for me das nyamisha.